Thank you for joining us today for the annual Homecoming Ethics CLE. My name is Georgette Vigil. I'm the Senior Director for Alumni Engagement and Outreach at Colorado Law. During the presentation, you can ask questions using the Q&A function at the bottom of your screen. Questions will be monitored as they are submitted. You can vote on questions that interest you the most. Amy will respond to questions following the presentation. As a reminder, everyone is on mute. Now it's my pleasure to introduce Dean Anaya. He is an internationally recognized scholar in international human rights and issues concerning Indigenous peoples. He served as the United Nations Special Rapporteur on Rights of Indigenous Peoples from 2008 to 2014. In addition to his teaching and scholarship, Dean Anaya has litigated major cases involving Indigenous peoples, human rights in domestic and international tribunals. Dean Anaya.
Thank you, Georgette, and good afternoon, everybody. Welcome to this afternoon's Colorado Law Homecoming, virtual homecoming ethics presentation. The theme of today's presentation is what keeps law firm leaders up at night. I'd like to begin by recognizing that the University of Colorado is located on land within the Ute, Cheyenne, and Arapaho Peoples territories. Further, we acknowledge that 48 contemporary tribal nations are historically tied to the lands that make up the state of Colorado. The annual Homecoming Ethics CLE is a long-standing Colorado law tradition, and although we're not together in person this year and without a football game to follow our ethics CLE, we're grateful to offer this session remotely. We're also grateful to have a repeat performer giving the presentation today, Amy DeVan. Amy earned her JD at Colorado Law in 2001 and is the executive director of Wheeler, Trigg, O'Donnell, overseeing operations for the firm. Amy has spent a significant part of her career advancing legal ethics in the profession. Before joining Wheeler, Trigg, O'Donnell in 2016, she founded and managed Principal Legal Consulting, which proactively helps lawyers and law firms comply with ethical rules and regulatory requirements. You can learn more about Amy DeVan's impressive background in the detailed biography that's been made available to you. I'm now delighted to turn the program over to Amy.
Well, thank you very much, Dean Anaya, and thank you to Georgette and Yesenia as well for all the help they've given me in putting this together. And thank you to the now 170 people who have logged on to join us today. I'm excited to see all of you. I'm going to share my screen so we can talk about what keeps law firm leaders up at night. And I'm hopeful that I can't see all of you. And in some ways that's bad because I can't tell if you're laughing at my jokes and I can't feed off your energy. But in some ways it's good because I'll just tell myself that you're laughing at my jokes. And I think I'm hilarious. So I'm going to pretend you do too. So what keeps law firm leaders up at night? I'm really hopeful that at least some of the 170 participants out there in internet land are WTOers. And I'm hopeful for that because I think after watching this today, you'll maybe think I'm a little less of a crazy person. You'll realize that I'm sleep deprived and you'll realize why. So I really tried to tailor this presentation for those of you who work in all size firms, whether you're a solo, a small firm, a medium firm, or a large law firm. I think I have nuggets here that will apply to everyone. So my big question for you is, it's 4 a.m. What are you thinking about? When I came to Wheeler, Trigg, O'Donnell, I came here as Ethics and Conflicts Counsel. And I moved into the executive director role in mid-2018. And at that time, everyone said to me, it's a big job, give yourself a couple of years. 2 years is really the benchmark for a job like this, and then you'll feel like you have it down. So I thought, okay, great, 2 years. I can get to 2 years. So I muddled my way through, sort of just jumped off the cliff and tried to figure it out as I went along with great help from the leadership here, as well as the partners, the associates, and all the employees. Really looking at that 2-year mark. Well, if you can do math, you realize that 2 years was mid-2020. And what happened? A pandemic hit. So just my luck, although thankfully, given the effects this pandemic has had worldwide, we can't feel too sorry for ourselves. But what the pandemic really taught me is it's all about throwing out the playbook and just figuring it out as you go. And to some degree, I think that's what we all do. Law firm leaders had worries pre-pandemic. That hasn't changed. But what has changed is how those worries play out in real time. They've become more intense in many ways. And so it's really a matter of what have we always worried about and what should we always be thinking about? And now that we're in this new world of pandemic time, how did that change? So there's a few broad areas that we're going to talk about today. Competence. Should you take the case? Are you competent? Do you have the resources? Diligence. Especially now, there are some days you just don't want to get out of bed, but you still need to pay attention to your cases and your clients. Conflicts. Don't let your guard down. The desire to keep business flowing is understandable, but now more than ever, conflicts are important. Communicating with your clients, again, maybe more important now than ever. The one thing I always told lawyers when it comes to communication is you have 30 cases on your desk. Your clients have 1 case. So they're going to worry about it. And in this time when there's really no place for any of us to go, they have a lot of time to worry about it. So communicating is critical. Technology. I'm going to try to pace myself today and spend a good amount of time on each topic, but I'm going to warn you in advance that when it comes to technology, I can go down the rabbit hole. This is probably what keeps me up most at night. And when it's 4 a.m. and my eyes pop open, usually I'm thinking about something that I've read in the news or something that I'm worried about, and it almost always relates to technology. Money. Don't let the money be what trips you up. If you're like me and you're not great with money, that's between you and your personal bank. But when it comes to your client's money or a third party's money, that's when other people get involved. So make sure the money doesn't be what trips you up. There's very little else to say other than malpractice risks. I worry about it. Law firm leaders of every size worry about it. And all of you out there should be worried about it because it's your license on the line. So be thinking about that as well. And then the intangibles. Now that we're all scattered, we don't have daily contact. What's happening with us as people? I spend a lot of time worrying about people and worrying about what's happening with our people. And I think it's something we're all struggling with right now. So we'll talk about that a little bit too. Competence. I'm going to just offer a caveat. If you know me, you know that I'm allergic to everything. I always say that I don't go outside because if I'm not afraid of it, I'm allergic to it. So although this topic is very near and dear to my heart, I promise you I'm not crying. I just have to dab my eyes because they water because I'm allergic to all of life. So competence. You can take the case, but should you? So throughout the presentation, I'm going to pop up the rules. You obviously know, because I'm sure you all read the rules regularly, and I'm referring to the rules of professional conduct, that they're much longer than this. I'm just giving you a highlight and an overview, and there's also comments, and the comments can be really instructive. So I'm going to give you the highlight to the rule, but please go read the rule for yourself. I say that assuming you haven't, but I'm sure you already have. Also, through this presentation, I'm going to use the Colorado Rules of Professional Conduct. So for reference, when I refer to the rules, that's what I'm referring to. If you practice in another state, you need to also be aware of that state's rules because there can sometimes be subtle differences. So again, you can take the case, but should you? There's temptation to take any case that walks through the door. And I think a lot of times that's driven by a fear that another one might not be right behind it. And that's understandable, but not if you don't actually know how to do it. I had a really interesting conversation a couple of years ago with a lawyer who is a partner in a mid-sized firm. I would say probably 15 to 20 lawyer firm. And she had been practicing for about 20 years. And she told me, we were having breakfast, she said, I just turned down my first case last week. And I was shocked that she hadn't previously turned a case down. And she said, I just thought the client needed more than I could give them, given where I'm at right now with my caseload and what they were looking for. But she said, it's the first time I've ever felt comfortable turning down a case. And I was shocked by that because this was a hugely successful lawyer, very involved in the Bar Association, the managing partner of the firm that she helped found, and that she had that level of insecurity about what was going to come next. Was kind of a revelation to me. So I understand that, but I also think it's important to have that self-awareness of what can I give? Can I give this case what it needs? And can I be there for the client? Think about diversifying, making your practice more flexible in times of crisis. And I think sometimes that's what we want to do. But again, are we competent to do it? Can we do it? Maybe there's a little boredom creeping in. You're sick of being at home and looking at your four walls, and you want to try something different. Stop, slow down, and ask yourself, am I competent to handle this? I can take it, but should I? And don't dabble. Too many cases are complicated and they're growing more complicated. And all of you out there that specialize in a certain legal area think that your legal area is the most complicated one. And dabbling is just a really bad idea. If you're going to do it, figure out how to do it right. Sometimes we all want to change practice areas or take on a case in another practice area, and that's not forbidden. We can do that. We just have to be thoughtful and we have to be careful. I noticed Georgette pop in. Georgette, did you need to pop in or are you good?
I just wanted to let you know, so, thank you for noticing. You're in your notes, so you're in note view, just so you're aware.
Okay, let me figure out how to change that. Let's see. Give me one. See, this
Perfect.
is technology.
Perfect.
Are we good?
You're good.
Okay. So you guys were seeing that black screen that I actually don't really like. So stop, slow down, and ask yourself, am I competent to handle it? I can take it, but should I take it? And don't dabble. So since you saw the notes, I gave away my story, which is the kid who wanted to teach himself immigration law with books. So prior to going out on my own and starting principal and coming to Wheeler Trigg O'Donnell, I worked at the Office of Attorney Regulation Counsel, and those of you who know me know that, and I talk about it a lot, and I'm going to talk about it today. But while I was at the Office of Attorney Regulation Counsel, in my prior life of private practice, I spent 9 years practicing immigration law. And so one of the lawyers came to me and said, I have this young friend, he's just graduated law school, he's been out for a couple of years, and he wants to become an immigration lawyer. So will you meet with him and talk to him about how to do that, about what he should do, and about how he could go about it? And I said, absolutely. If you guys know me, you know one of my favorite things in the world to do is meet for coffee. I could be a professional coffee haver. So I'll have coffee with anybody. So I meet this kid for coffee, we're talking, and I didn't think we were off to a great start when I said, talk to me about why you want to practice immigration law. And he said, I really like to travel. And I said, okay, well, what does that have to do with immigration law? And he said, well, I like people from other cultures. Okay, fine. So I said, well, what area of immigration law are you most interested in? Are you interested in corporate, individual? What are you most interested in? And he didn't know. And then he told me he thought maybe asylum. And I think that's because everyone knows that asylum is part of immigration law. And I think he was just jumping at the first thing he could. But if you know that, you also know that asylum cases have huge ramifications. And you really are making the difference between someone who is asserting a claim of having fled their home country for fear of their safety, that's a big deal. I mean, if they get sent back, they're voicing a fear that they could be physically harmed or even killed. So you really don't want to mess around with this. So I said, that's great. That's laudable. That's a really good goal. But how do you plan to do this? And he wasn't involved with the Bar Association. He didn't have a mentor. So we were not off to a good start. And he told me he bought a book. And that was his plan. He was going to read his book, and then he was going to start taking asylum cases. And after I was able to get my breath back and worried that I was having heart palpitations, we talked through why that was a really bad idea. So I kind of over dramatize the story in hopes that you too would realize that that was a really bad idea. And it is, it's a really bad idea. So don't dabble, don't teach yourself from a book. If you want to switch practice areas and you want to try something new, that's a great goal. Just make sure you do it right. And getting involved with the Bar Association, building a network, consulting good resources that aren't just one book is the way to go. Be realistic with yourself. Do you have the capacity to take something on? And do you have the tools and the staff you need? That overlaps with diligence, which you also saw was the next slide because I gave it away. But make sure you can do it. And then finally, don't teach yourself how to do new cases without mentorship and resources. And the biggest thing is let the client know the true state of your experience. I had a lawyer that I investigated while I was at the Office of Attorney Regulation Counsel, and this was a lawyer who handled immigration cases. And this lawyer had been, we had visited prior to this conversation, let's just say. And this lawyer had filed something that patently should not have been filed. The client was not eligible for it under the law, and that was clear. And I said to the lawyer, like, why did you file this? Your client was never eligible for this relief. And the lawyer said, well, I think that's unconstitutional. I think it's unconstitutional that the client can't apply for this relief, and I wanted to test the law. And I said, super, but did you tell the client you were using them for a test case? Because if you didn't, not only did you fail to communicate, but you weren't competent to do what you did because you didn't talk about it with your client, which makes me wonder whether that's really what was happening here. So don't make your client the test case. And if you want to take on a new matter and you haven't previously done it, you need to let the client know that. So diligence, right? You've decided that you're competent. Now you can take the case. But do you know what it really takes? And do you have the tools to make it happen? That falls under Rule 1.3 of the Rules of Professional Conduct. You need to be honest with yourself. Anytime, but especially in COVID times, do you have the bandwidth to take on a new matter? Can you take this on? Are you already at capacity, right? Again, we talked about you don't want to turn down work, but you have to ask yourself, is this something I can do remotely? Am I teaching my kids because their school isn't open yet and I'm doing homeschooling? You potentially have a spouse, a roommate, a significant other, a partner, other people working in your same space. There's a lot going on right now. Life is heavy. Can you take this on, and do you have the bandwidth? Not just generally, but for this specific matter. What resources are needed, and do you have them? And here, this is more about what's out in the external than it is just about you. Think about personnel, capacity, and general resources. Is this a matter that you're taking on a contingent fee and you're going to be agreeing to front costs or take any financial risk? Are you prepared to do that right now? What's the financial state of your practice? And is it such that you can take something on spec? You got to think that through. And this is a new one to the age of COVID, right? We're always worried about taking on a matter, making sure we have the bandwidth, making sure we have the resources. But new to the age of COVID, throw in remote work, right? Is this a case that lends itself to working remotely? Is it document heavy? Do you think you're going to want to have notebooks or hard copies printed? Here at Will or Trigg, we have lawyers who love their notebooks and they want a notebook. Anytime a new case comes in, let's start building that notebook, right? And that's great. That's how they practice. That's what they're comfortable doing. You can tell from the state of my office that I'm the opposite. I am not a paper person. And so for me, work going back and forth between remote work and in-office work is just fine because I do everything electronically. But not everyone does. So think about that. Think about how you prefer to work and then think about what this case might require. Are original signatures going to be needed? Are you going to have FaceTime with the client? And is that realistic? And is there enough time to get done everything you'll need to get done? Is this a case with a really fast turnaround deadline at the same time as you have 10 other cases with fast turnaround deadlines? You just have to think about what you've already got going on. Don't be afraid to admit to yourself and to the client that you might not be the right person or this might not be the right time, right? It's not a show of weakness. You're not a bad lawyer. It's just really being realistic about what you can handle and what you can do for the client, because we always need to be thinking about the client first. If it is the right time and you're the right person, plan ahead, map it out, especially given the challenges of COVID. It's been an interesting conversation to have with people here, because there's a cohort who's like, this is amazing and I'm more efficient at home than I ever was in the office, and you're basically never going to see my face again. And then there's a cohort like me who I've been coming in throughout, and it's just my preference. Luckily, I was able to designate myself as essential staff and come in with our skeleton crew of 10 to 12 people who came in during the height of COVID just to keep things moving. I really prefer to be at the office. I am not as efficient at home, not least because I have 3 dogs and a husband who works from home all the time. And I just prefer to be at work. And so it's really just thinking about, where am I actually more productive? And can I be there right now? If you can't be at your office, or it's just not realistic given the other responsibilities that you have, think that through. Conflicts. You can tell by the fact that I told you that I was ethics and conflicts counsel prior to moving into the executive director role, that this is a topic near and dear to my heart. And so I'm obviously going to have a lot to say about it. But the biggest thing I can say is, don't tell yourself you'll just figure it out later. I know that I, and now our conflicts and ethics counsel, who I stole away to replace me, Sarah Van Duzen, both would say conflicts are the single most important thing you need to be thinking about when you're taking in a new matter. I think most of the lawyers think that we're really annoying when we press that, but it really does matter, and it's not something you want to figure out later. There's a few different rules when it comes to conflicts. There's Rule 1.7, which is the primary rule. And then there's Rule 1.8, which follows along conflict of interest current clients. We're going to talk about that a little bit below. And then there's Rule 1.9, duties to former clients. Yes, that's actually a thing. When the representation ends, your relationship with the client doesn't just automatically end. Rule 1.10, imputation of conflicts of interest to other lawyers in the firm. That's also actually a thing. There are certain conflicts where if one lawyer in the firm has a conflict, all the lawyers in the firm are conflicted out. That's always shocking to people and unwelcome news. And then Rule 1.11, special conflicts of interest for former and current government officers and employees. So if you're bringing someone into your firm or you're starting your own firm after having been a government lawyer, there are special conflicts rules related to you and related to the work that you did while you were with the government and what you can take on in private practice. And that's actually really important, because often when government lawyers transition into private practice, either because they're hanging out their own shingle or because they're being hired by a firm, it's exactly for the expertise that they gained while working for the government. And it's kind of surprising sometimes to know that there are limitations on that lawyer's ability to practice in that space. So it's important to understand that. Conflicts may be waivable if the lawyer reasonably believes that she can provide competent and diligent representation to each affected client. The representation is not prohibited by law. The representation does not involve the assertion of a claim by one client against the other in the same legal proceeding, which would be a direct conflict, and that's not waivable. And each client gives informed consent in writing. You don't always need to have the client sign something. What I prefer to do is have a conversation with the client first and say, hey, we may have a conflict. Here's how that's going to play out. Do you agree that you're comfortable with that, or do you not feel comfortable with that? And if they say they're comfortable with that, then I'll typically follow up with an email and I'll say, dear so-and-so, thank you so much for talking to me today. As we discussed, we have a potential conflict here. Here's what that looks like. You've indicated to me that you're comfortable with it and that you waive any concerns and that we can proceed. If my understanding is incorrect, please let me know within the next 48 hours or whatever it may be. And that works really well because then you've given the client, you've confirmed in writing that the client gave informed consent. That doesn't always work, and it doesn't work in certain states. So again, be aware of your circumstances, but you don't always have to have them sign something. If nothing else, you could have them send you an email or whatever. And then the other thing that I think is really critical to understand is conflicts may arise over time. A representation that looked fine at the outset may pose a conflict later on. Perhaps a witness gets added, new counsel comes into the matter. So it's critical to be aware of your case as it evolves. Conflicts make things worse, right? Many conflicts can be caught in the beginning and resolved outright. The majority of conflicts that we catch are waivable. We just need to communicate with the clients. Or if it's not waivable, we at least catch it and go to an alternative plan of action before it becomes a problem. Often the alternative plan of action is we can't take the case, but it's better to know that than waiting, 3 or 4 months, 5 months, 6 months longer down the road before the conflict comes to light. And then you're faced with potentially a motion to disqualify, you have an angry client, you look like you're unprofessional because why didn't you know this? And you potentially have to disgorge significant fees that you shouldn't have earned because of the conflict. So even if the conflict, the result is you can't take it, it's better to know that at the outset. So what can you do? Run conflicts every time. The end. Every single time you run your conflicts. Get accurate and complete information. Make sure everything is spelled correctly and proofread when you're running your conflicts. It does not help anybody if you run the wrong name or you run a variation of the name. And we've seen that. We've seen that, and I think every law firm has seen that, where a variation of the name was run, but not the, maybe the client spells their name in a really strange way and it didn't come up. So make sure you're spelling everything correctly. Open new matters every time. And this is something, on the one hand, you're going to say, of course, but really you're probably not, right? You're handling the matter and either the decision goes against you, or you got the decision you wanted, but then something happened, or you got the decision you wanted, but the other side's unhappy, so they're appealing. But either way, there's more work to do. So now you transition from the main case to the appeal, right? Most lawyers will just keep on working. You really should run conflicts again and open a new matter for the appeal. That way, by opening the new matter every time, it prompts you to be sure that you have updated conflicts information. And watch for changes downstream. Names, parties, subpoenas. We see a lot that, we need to serve a third-party subpoena on this person. You got to run conflicts on that, right? Because if nothing else, you want to let the relationship lawyer know, hey, I'm going to be serving a subpoena on your client today. Like, that's something they want to know. So make sure you're watching for those changes downstream and you're updating conflicts as you need to. And then don't make the mistake of spotting a conflict and telling yourself it's really nothing. It's not that big a deal. It's theoretical. It's never actually going to come to pass. If it's a conflict and you need to deal with it, right? Don't punt it and have to deal with it later and make things harder on yourself. And we recently had a presentation from our malpractice insurer, Alas, and the Alas lawyers like to talk about this a lot. In malpractice matters where conflicts are present, even if the conflict is only minor, juries almost always award exponentially more money because they assume that the lawyer was disloyal, and that really offends them. So you see these cases where the conflict itself was really small, but then the bigger issue, right, was the malpractice matter. And then that gets resolved and it turns out it really wasn't that big of a deal. But because you had this conflict issue over here, even though it was small, juries think that you didn't live up to your duty of loyalty and you should have put your client first, and you put your own self first, you put someone else first. And that just exponentially increases their award. That seems really theoretical because you think to yourself, well, the goal is just to never get sued for malpractice, and that's all of our goal. But just be aware of it and be aware of the importance of it. Communicating with clients. And I put the subheading here because I think it's really important. It's really, really important to communicate even with the troublesome clients. It's probably especially more important to communicate with the troublesome clients. And we all have those clients, right? We all have the client that we'd rather just not deal with. the phone rings and you sort of just shake your head or roll your eyes or just like you dread picking it up, right? It's the client you really don't want to talk to. That's the client you probably most need to talk to. Rule 1.4 tells us about communication. And the gist of all of this here is communicate with your clients. Rule 1.0e, which is referenced here on the screen, defines informed consent as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. So really giving your client the full picture. If you don't give your client the full picture, then it's questionable whether they gave informed consent. And it's sort of like that lawyer that I told you about in the very beginning that told me that that he was filing something that was statutorily ineligible because he wanted to make new law. You know, if he didn't have that in writing to his client, and his client didn't indicate that there was agreement to that, then there wasn't informed consent, especially to something so radical, right? I'm going to file something you're not eligible for, and it's probably going to take years, and it's going to go up on numerous appeals, and in the end it may not go anywhere, and you're going to be removed from the United States. Like, that's really something the client needed to know the details of, and that's informed consent. The one thing I always tell lawyers is it doesn't matter what fancy school you went to. It doesn't matter how many degrees and honoraria hang on your wall. It's the client's matter. It's not yours. And it's important to understand we're in a customer service occupation. Lawyers don't like to hear that, right? Because they think of customer service as retail. Well, that's what we do. We are in the customer service business, and our clients are our customers. We just call them a different name. Keeping them happy, serving their purposes, getting them where they need to be has to be our goal. Now, the first one, keeping them happy, sometimes is an impossible goal, and I get that. And sometimes you have to deliver bad news and your client's not going to be happy. But in the end, you're helping them. And I'll give you a perfect example. When I practiced immigration law, I had this series of law clerks that worked with me, and they all ended up going on to law school. And one of the clerks that worked with me the longest, she worked with me for a couple of years, said to me one time, she was a Spanish speaker, and I did not and do not speak Spanish. And she said to me, I feel like this is taking a toll on me. Like, I'm getting really depressed because I feel like I'm just always telling people that there's nothing we can do for them. And I understood that. I get that. But I said to her, knowledge is power, right? And by communicating the reality of the situation to these clients, we are preventing them from being taken advantage of by an unscrupulous person who is going to tell them whatever they want to hear and, you know, have them shoot for the moon. And the consequences in immigration matters are very severe because often the client is unknown to the immigration service. And so you're turning them in, basically. And you got to be sure about what you're doing. And the client has to know the consequences or the potential consequences for that. So it's the client's matter. And even though they may be annoying, they may be a little bit inconvenient, they need and deserve to know what's going on. I'll tell you honestly, every case that I had at the Office of Attorney Regulation Counsel ended up having a lack of communication at its core. I had a client call one time and say, I think my lawyer is stealing money. And that's a really serious accusation. We're going to talk about money shortly. But when we got to the root of why this client thought the lawyer was stealing money, it was because the lawyer just hadn't explained to the client how something was going to work. In this particular case was a personal injury matter on a contingent fee. And so the lawyer, you know, the client was like, my case settled like 30 days ago and I still don't have my money. And so I guess it's obvious the lawyer has stolen it. Well, no, it's not obvious the lawyer had stolen it. You know, a settlement was reached 30 days ago and then the insurance company had to cut a check. It had to be sent to the lawyer. The lawyer had to resolve any liens that were on that money. The lawyer had to calculate out what what was going to go to the client under the fee agreement and all of those things. And so there was all these nuances there. And it turned out that's exactly what had happened. And the lawyer obviously hadn't stolen any money, but because of the lack of communication, it led the client to go right to the worst case scenario. And so don't underestimate how important communication is. And I'll reiterate, you may be juggling 30 cases, and this may not be the most important one of those 30 cases, but it's the only case they have, right? They're worried, they want to know what's going on, and they want to understand what's happening. And you can help control that to a degree by setting expectations from the start. How are you going to communicate with your client? What can they expect from you? I had cases where we would send it off and we would have to wait for a prevailing wage determination, for example, from the Department of Labor, and that could take 60 or 90 days. And I would always say to the clients, I don't want to bill you unnecessarily. If you have questions, you are welcome to call me. But until I have an update, I'm not going to be calling you because I don't have anything to share. And I let them know that at the outset, right? And so it's important to do that. But it's also important to live up to whatever you say you're going to do. Once you set those expectations, they're expectations for the client, but they're also expectations for you. Here's where we get to my favorite subject. And I will try not to go down the rabbit hole. I'm keeping an eye on my time, but I could talk about this all day. It's a brave new world. Technology is something that we can't underestimate the importance of, especially today. I don't know how all of you sort of handled the transition into lockdown, but here at WTO, we went from 100% in office. We had, we're an in-office firm. If lawyers aren't traveling, they're here. We went from 100% to 100% remote, with the exception of the 10 or 12 essential staff that I mentioned, in 48 hours. The only way to do that is through technology. And I could not be more grateful that our IS director, who came on board about the same time I transitioned into the executive director role 2 years ago, had the foresight to say, there's improvements we need to make, really just going forward to our infrastructure, because it enabled us to make that switch and to make that switch as quickly as we needed to. And all of you probably experience the same thing. So what we're doing today, is a new method of using technology in a way that we hadn't before, right? Zoom didn't just get invented because of the pandemic, but we had used it in ways that differ from how we're using it now. So it really is a brave new world. I'm going to be honest with you. A couple of, I would say maybe a year ago, this whole splash came out about, oh, they're updating the rules of professional conduct to say that you have to be technologically adept. And it's a really big deal. Like, you can no longer stick your head in the sand. You got to know technology. Okay. So I honestly hadn't really looked at the rules as it relates to technology. I sort of just took that at face value. So then I looked at the rules and I was like, okay, what do the rules say about technology? And the answer is not that much. So I think the hope is that people embrace technology, but in terms of the rules, there's not a lot there that says, like, you need to really know how to work technology. This is from Rule 1.1, Comment 8. The competence rule: to maintain, the requisite knowledge and skill needed to practice law, you need to keep abreast of changes in the law and practice and changes in communications and other relevant technologies. So it's there, but it's not that robust. Same here, duty of security. I like this one because while I titled the other one Duty to Know What You're Doing, this one is, you have a duty to keep the information safe. And this is the part that just sends me down the rabbit hole of fear, that it truly does wake me up at 4 o'clock at night or in the morning. And I will tell you again, our wonderful IS director, part of what makes him so wonderful is that he is tolerant of me, because I will often be at home late at night. I'm that guilty bad person who sends emails late at night. Luckily, I've told everyone there is zero expectation that you respond to me late at night or on the weekends. But if I'm thinking it, I got to get it out. And so I'll send him emails late at night, like, I'm just reading this ABA article or this new article on Law 360, and they're talking about this, and now I'm terrified, and let's talk first thing in the morning. And he does a really good job of talking me off the ledge and talking to me about realities and talking to me about things that he's done to remediate our risk. But it still makes me paranoid. And it makes me paranoid because no matter how good you are, hackers are always trying to get better. And they're always coming up with new ways to target us. So we're going to talk about outside counsel guidelines, requests for information later. But the one thing you should know when it comes, especially to this rule or this comment to the rule, see, that's the part I don't like, it's not even a rule. Rule 1.6 comment 19 is, it really tells you you have to safeguard your client's data. This is a growing area for corporate clients. For those of you out in internet world who represent corporate clients, you know the bane of your existence, the bane of our existence is the outside counsel guidelines. Sometimes they're super reasonable, but sometimes they're very, very onerous. And the time will come when clients aren't just asking you what you're doing in a request for information or an outside counsel guidelines, but they are requiring you to follow their standards. And their standards may not be your standards. They may be far more strict than what you're currently doing. In some instances, that time is now. We're starting to see more and more really strenuous outside counsel guidelines, especially in the area of technology. So it's something that you really need to be aware of. You also need to be aware of the various local, state, national, and international laws. As you all probably know, California has its own data privacy laws. There's the GDPR that came out a couple of years ago that everyone's still scrambling to try to figure out how to navigate and comply with. So you need to know, based on your practice area, what laws may implicate you apart from the rules of professional conduct, because you have to comply with those too. Comment 18 of the same rule was a little less exciting, so I didn't cite to it, or I didn't type it out for you, but I'll just tell you that it also requires that you take precautions and use reasonable efforts to safeguard information relating to the representation of a client in terms of preventing unauthorized access by third parties against inadvertent or unauthorized disclosure. So think of this both as sending to someone you shouldn't information relating to the client, as well as not taking adequate security precautions. So there's the classic unintended disclosure where you accidentally sent a document, right? In the olden days of sending documents, in the before times where you would send mail, right? Remember mail? You sent a piece of paper to someone that shouldn't, and then you wrote them and said, hey, I didn't mean to send you that. Can you send that back to me, or just destroy it or shred it and tell me you did, and I'm going to trust that you did. Nowadays, it's more like I sent an email I shouldn't have. The classic example of reply all. Reply all is, I think, the worst invention ever, next to the Trigg, because it just lends itself to such risk. There's so much risk related to reply all. Not only I sent an email I shouldn't have sent to that person, I meant to send it to this person and I used autofill, or I just hit reply all and I didn't realize who was on there. But when it comes to representing a client, there's this whole, ethics lawyers are like cartoons. I told my mom, you sit in a room with ethics lawyers and it's like you see light bulbs popping on over their head when they think of this idea, and then they all start going down the rabbit hole and it's really becoming about the minutia. But there's this big thing in ethics circles of, if you use reply all and the lawyer who sent you an email copied their client and you're the opposing counsel and you reply all, are you having an impermissible conversation with the other lawyer's client in violation of the rules? And there's all this other stuff that is involved there. So A, reply all is a bad thing. And then B, don't ever include your client on an email to opposing counsel. Just send them the email separate. But that's what this is talking about, right? Unauthorized disclosure. I sent something I didn't mean to someone, and now I got to figure out how to fix that. But it's also talking about, are you taking adequate precautions to protect what you have? And that's the part that makes me nervous all the time, because no matter what adequate precautions we take, someone with a nefarious intent and a motive, and let's be honest, better skills than I have, is on the other end trying to get better and trying to trick us. Mishandling data can leave you open both to a malpractice suit for failure to preserve confidentiality and comply with minimum standards of care, as well as the costs related to logistics of remediating and solving the problem. So you need to just be at the top of your game all the time when it comes to protecting your client's data. I'm not super tricky, so I don't have video or anything fancy, but I think this slide speaks for itself. So I was working with a lawyer before I came to WTO. What I really wanted to do was work with lawyers on how to be better lawyers. Both lawyers who had come into contact with the Office of Attorney Regulation Counsel and sort of had been told that they had to become a better lawyer, as well as lawyers who really just wanted to be proactive and make sure they were complying with the rules and practicing in the best way possible. So I'm working with this lawyer. This lawyer was a solo practitioner. It was a male, and I went to his office. He office shared with another person, and he had his own, locked office within a 2-person suite. And he didn't have a lot of technology in his office. And I said, okay, let's start with a conversation about how you're backing up data, right? In the event there's a catastrophe or something happens, how are you backing up your data, and how often, and where are you storing it? And he reaches into his pants pocket and he pulls out a USB drive, just a run-of-the-mill everyday little USB drive, just like this, not a removable hard drive. And I said, is that your backup system? And he said, yeah, I don't have that much data, so it fits on here and it's perfectly fine. And I was like, what happens if you forget it's in your pocket and you wash your pants? Because I don't know about you, but if something isn't where I put it, I'm going to forget it. And anything that's in my pockets is fair game, to the point where my husband's like pulling stuff out of the dryer and is like, this doesn't even make sense that this is in the dryer. So what happens, right? Because I can guarantee you, if this goes through a wash cycle and a dry cycle, it's not going to work. So we had to talk about that, and we had to talk about really thinking about what fit the needs, but that was more secure and was more realistic. So those of you out in internet land who are solos or work in a small firm, please don't let this be your data backup, at least not your only data backup. These are handy, but these are not intended to be your only data backup. And second to that, don't store this in your pants pocket. Know what you need and know how to use it. My brother is a Chevy mechanic, and so I'm pretty sure my niece knew how to say the word Chevy before she knew how to say mom and dad. And so out of loyalty to my brother, I always say, if you need the Chevy, buy the Chevy, right? You don't need a Cadillac if you're not going to use everything the Cadillac comes with. So know what you need, know how to use it, and be realistic. And I'm going to use myself as a perfect example of this. So you can tell I'm at work, and I've told you that I'm here. Here at WTO, like many of you out there at your firms, we have several conference rooms that are Zoom enabled, as well as a fully equipped mock trial room. But I am coming to you today from my office wearing my fancy $30 headset that I bought at Target. And I'm doing that because this is a level of technology I can work. Despite the first 5 minutes of the presentation when I was showing you the wrong slides, I can work this technology, and I knew this technology was going to work, and I knew I wouldn't have any glitches with it, and I knew I wouldn't have to get anybody to come help me, and it serves the purposes, right? You can hear me perfectly fine. I can't hear you because you're all muted, but if you were talking to me, I could hear you perfectly fine. You can see me, you can see the slides, and it works just great. So know what you need and use that, right? I can use this. This works for me. I wouldn't be able to use the mock trial room by myself. I would have to have someone come and hook it up. I would have had to do a test run. I would have had to do all these other things. The moral of that story is you don't need the highest priced equipment or software, right? You need the equipment and the software that meets your needs, that you know how to use, that you will use, and that meets the expectations of your clients. and that's what I told this lawyer. Like, because then once we talked about the fact that the USB drive in the pocket was not a good idea, what do I need? Do I need this like Mac Daddy system that is going to bankrupt me and that I'll use 1/3 of? Or do I need this more modest but perfectly adequate system that meets my needs and that I'll probably get full utilization of? You can guess what the answer is, right? Know what you need and use it. If you don't know what data security means, much less how to ensure it, then please just pay someone who does. Because data security is the name of the game. Like, you've got to be serious and be real about securing the data. Not knowing is not an acceptable excuse anymore. In COVID times, it's almost impossible to practice without technology. But even in not COVID times, understanding technology, both its benefits as well as its risks, is critical. And I have this, again, sort of rudimentary, unfancy note here for you not to be like my mom. I love my mom, but every time I am talking to my mom on the cell phone and it cuts out, it fills my soul with dread. And it fills my soul with dread because I know this is exactly what's going to happen. I'm going to call my mom back, even though I debate with myself as a daughter whether I can get away with not calling her back. But then I'll get a series of texts that's like, what happened? Are you dead? So I call my mom back. And the second I call her back, every single time, this is what I hear. That was weird. And it's like, no, it wasn't weird because it's a cell phone and cell phones cut out and that's technology and that's just how it works. And every time I get the same response, well, I don't do technology. Well, right, that doesn't really work for me. And that doesn't work for the rules of professional conduct. You don't get the luxury of being like my mom, who can stay home and just crochet all day and play with her dog and not do technology. You don't get to do that. You're a practicing lawyer. So you have to do technology and you have to know what you're doing. So what's your plan? This, for all of you from WTO, and you wonder why I'm crazy, this kind of stuff is why I'm crazy. What do you do if your employee tells you that she left her laptop behind in an Uber while she was traveling on personal travel? And by the way, you should probably know that she overrode the firm's security protocols twice. She turned off the automatic locking because it was just very inconvenient that the computer locked after 15 minutes. And she also overrode the password protection because she could never remember her password, but she could figure out how to override that in the security settings on that laptop that is now unsecured and floating around in an Uber. Or your employee fell for a scam email and wired a substantial amount of payroll funds to a fraudster's bank account. You guys probably get those emails all the time. We get them constantly. That purport to be from someone. I just saw something from our cybersecurity provider today where fraudsters troll your website to get personal details about your lawyers or your finance staff or whoever it may be. And then they send emails that look very realistic to the human resources department and purport to be from that person and ask that they just change the payroll deposit just for this one paycheck from this account to this account, right? What are you going to do if your employee responds to that? What do you have as a remediation plan? Your employee responds to a phishing email and provides her password. And her computer is now madly scrolling as the hacker is downloading all the data that he can get his hands on from that machine. What's your plan for that? Or what's your plan for any of the above if your employee didn't tell you in real time and waited hours or even days before they let you know? What if a fraudster convinced your employee to fall for a scam and installs ransomware on your server? If that's not keeping you up at 4 a.m., it should be. You now can't access any of your files, and the monetary demand for releasing them is getting higher and higher as the scammer goes through your data and realizes what he was able to get. Do not think you're not a target. Do not think that for any reason, I'm too small, I don't have clients anyone cares about. Your data is valuable to someone somewhere, right? That value is relative, but all you have to do is look online and see what credit card numbers are selling for on the black market, what social security numbers are selling for, what credit card numbers plus social security numbers are selling for. Forget things that bigger firms are targeted for, which is which mergers are happening. How can I manipulate the stock market based on some of that? If you advertise on your website like we do and like every other big firm does about who your clients are, oh, okay, well, I know such and such client. I read in the news that they're involved in talks to merge with this other person or this other entity. I wonder how that's going. This law firm says they represent them. I'm going to hack in and take a look at their files and see if there's any updates on what's the status of that acquisition. And then I'm going to start buying stock. It's happening. It's happening in real life. So you might say to yourself, well, I'm a solo practitioner. I just do, I do family law cases. No one wants my data. You've got data that someone wants. No one has perfect answers. I don't have perfect answers to any of this, but you have to be thinking about it and you have to be making a plan. Safekeepi Shaw just was targeted over the weekend. Several other big firms have announced that they've been targeted. It's getting worse during COVID times. Hackers are assuming that because employees are at home, their guard is down, the safeguards are less, they might be more likely to respond to something. They won't have as many protections on their personal machine if that's what they're using. And so the risk is high and it's getting higher. You should consider insurance, not only additional malpractice coverage, but cybersecurity insurance. Back up your data somewhere secure, not this, whatever's going to work for you, whether it's a removable hard drive or it's cloud storage or it's physical storage. You've got your servers off site and you're backing up off site. Plan how quickly you can get data restored if you have to. Newsflash, it's not going to be the same day. Even in a firm like ours where you work as hard as you can and we could get back up to at least being operational in the same day, no firm can be fully operational same day. So plan for that. How quickly can you get your data restored and what are you going to do in the interim? Have contacts ready to roll if you need remediation. Have your IS on speed dial, maybe even a PR specialist, right? If you're big enough and this goes really awry, how are you going to manage the media on it? Reporting to authorities, notifying your insurer, all of this is stuff that's critical. Read your policy. Know what your cybersecurity policy covers and doesn't cover. That's critical too. And this whole thing with the iTunes cards, right? And you guys have seen these, we've gotten them too. Hi, I'm managing partner, which I realized because I looked on your website. I'm in a meeting right now, but I know you're going to respond to my email because I'm the managing partner. I need you to run down to Walgreens and buy $700 iTunes cards and email me back with the numbers of those. The fact that people fall for those blows my mind, but it happens all the time. So the thing I say here is, if it's not your preteen niece and it's not her birthday wish list, nobody needs you to buy an iTunes card today. So be thinking about all this. Money. The pandemic is no excuse for sloppy money. I did not type out the rule. We got ethics credits for this, so I have to tell you what the rules are that are related to all of these things we're talking about so that we're legit. I didn't type out the rule here because it's far too long and it's too important, right? It was too important for me to thumbnail the way I was able to thumbnail other things. So what I'm going to say to you is read the rule. Don't make money be the thing that trips you up. Failure to properly handle money is the quickest way to ensure discipline in the state of Colorado. The presiding disciplinary judge and our Supreme Court take this really, really seriously. And I'll give you a perfect example. There was a case in the Colorado Lawyer last month. Now that I'm not on the inside anymore, I have to get this news like you guys do, right? Reading the Colorado Lawyer. But there was a case where what this lawyer did didn't seem to be all that serious, except, oh, by the way, there was this failure to properly handle the money. And she got a 1 year and a day suspension. And I guarantee you the heightened level of that suspension was not due to the underlying stuff, which is really not as bad as a lot of other stuff you see. It's because there was that failure to handle the money properly. I've got the common mistakes listed here. Overdrawing the trust account. The bank will notify OARC as soon as that account goes into the negative. Failure to provide an accounting when requested, not promptly returning the funds when asked, and then failure to keep them in operating until earned. And those of you out there, including WTOers on this call, don't assume that you're immune because you work for a large firm, right? There is no exception in the rule based on firm size in terms of your responsibilities to your clients when it comes to money, right? You should have a basic awareness. Does your firm have a trust account? I would hope so. You should know that. Make sure you're properly accounting for your time. Make sure your billing practices conform to client guidelines. Make sure you're entering time properly and promptly, right? The client can ask for an accounting at any time. And if your time's not entered because you're behind on that, that's on you. You should have eyes on the bills before they go out. Don't delegate that to your assistant. Know what your staff is doing and make sure you have checks and balances in place. The person who is in charge of doing the wires out of your bank account should not be the same person who receives and opens your bank statements. Those should be two different people so that you can make sure that they're checking one another and the balances, are adding up. Just don't mess with the money. I had a lawyer one time who, and it's any number of things. It's just knowing the rules, right? I came from Georgia where you don't have a trust account. So I didn't know you had to have a trust account in Colorado if you held client funds. Well, that's your obligation. You're practicing here. Or I had a lawyer who got a debit card on his trust account, and you're not allowed to have debit cards and make cash withdrawals from your trust account. Oh, well, it's the bank's fault for giving you the debit card. No, it's your fault for getting the debit card because your professional obligations are that you shouldn't use it. And oh, by the way, now I know way too much about your spending history as a result of having to comb through your bank records, and you were just using this debit card like it was your personal bank account. And I don't know why you're shopping at Victoria's Secret, but you'd probably rather no one know that. So know what you're doing and follow the rules. What does your engagement agreement say? Do you have an engagement agreement? Does it define who the client is and the scope of the work you'll perform? Every single investigation, when there's an allegation against a lawyer, starts with, let me see your engagement agreement. And that answers so many questions. And if the answer is, I don't have an engagement agreement, that's a problem. I know what you're going to say to me. You're going to say to me, the rules don't require that I specifically have a certain type of engagement agreement. The rules require that I advise the client of the basis and rate of the fee in writing. And that's absolutely correct. But no one has ever in all these years convinced me there's any reason not to have an engagement agreement. The engagement agreement takes care of everything. And we have that conversation here a lot when it comes to how do we insert client-specific terms and what can we modify to meet client needs and things like that. You just always have to be careful because the engagement agreement really, if it's done right, it gives you the boundaries of the agreement of what you're saying you're going to do for this client. You have to define the client. You have to define your scope of work. If there's more than one client, you need to do a representation agreement. It's important to understand if someone beside your client is paying your bill, you still have a duty of loyalty to the client that you represent. And under Rule 1.8F, because I had that teaser earlier that we're going to talk about that, you have a duty to inform your client in your engagement agreement or in another writing that someone else is paying the bill and that there are consequences of that. You should check your agreement periodically to make sure it complies with the rules. And if you haven't updated it in a while with a specific client, do that. I mean, you can let an engagement agreement, especially for larger corporate clients that you represent all the time, you can let an engagement agreement ride and just incorporate it by reference. However, if it's been like 6 years since you updated it, it's probably time for a new one. Outside counsel guidelines, most people would say they're the bane of the existence of those of us who represent corporate clients, but they're here to stay. They're growing increasingly specific. Some would say onerous. I'm not going to admit whether I'm one of the some. Don't sign them without reading everything. Know what's in there. There are risky provisions. We saw an outside counsel agreement that basically said, if you do something that causes our data to be compromised, going back to data security, that can result in just unlimited harm to us. And so we're asking you to agree that you'll be liable for that, but we can't put a number on it. So basically you're agreeing to undefined liability, sometimes limitless liability, and that's terrifying, right? So read those agreements and know what's in there. You might be surprised. We saw an outside counsel agreement that required that we have a camera aimed at our server 24 hours a day to monitor anyone who accesses it. Do you have a camera aimed at your server 24 hours a day? Probably not. So read those and make sure you know what you're agreeing before you agree to it. And if you're in a big firm, I guarantee you your management is going to want you to run those up the flagpole so they're aware of them too, because sometimes they can conflict with each other. So just make sure you're vetting those properly. Malpractice risks, right? Yes, you should have insurance, and yes, you should know the risks. You have a duty to supervise, COVID or not, remote work or not, being in the office together, all of these things. You need to be thinking about how you're supervising what your teams are doing. How are you monitoring what your team is doing when it comes to your cases? What kind of check-ins are you having? How often do you think you're getting the information that you need? We implemented something here that was not well received at first because it was specifically for support staff who felt like it was very onerous, but it was give us a weekly snapshot of the cases that you have going on, where you are in those cases, and what's happening. And at first that felt very micromanagey to them, but the conversation really came around to, this is just a check for everybody. It's a check for everybody to better understand both what's on your desk, as well as make sure that nothing that should be on your desk isn't. And so it's really thinking about how you're going to do that in this brave new world. Are you confident calls and emails are being returned promptly? I don't know about you, but this feels like one long, endless day, right? I just wear a different shirt. Otherwise, it's the same as yesterday. And there are times where I've had conversations with people and I was like, remember that thing from the other day? And they'd be like, that was April, right? That wasn't the other day. So time gets away from us in the best of times, and this is not the best of times. So are you setting expectations for how quickly you want calls and emails to be returned? It should not be any different than normal. I had Jamie Sudler, my boss at OARC, always said, the sun should not set twice on a voicemail or an email. And I've always embraced that. I'm actually that crazy person where if I send an email and it's been an hour, I'm sort of a psycho, like, why are they just ignoring me? And I've had to talk to myself and tell myself that I need to calm down about that and give people a reasonable amount of time. In my mind, that's 2 hours. In most people's, it's 24. So set guidelines for people and let them know what you're expecting. Our events continue to be properly monitored, calendared. Is someone monitoring court rules for the changes? You know, at the height of the summer when everything was uncertain, things were changing all the time. We're keeping our same deadlines. We're moving our deadlines. It differed by court. Somebody's got to be keeping up with all of that. Are you fulfilling your commitments and doing what you said you would do? Are you making sure that all of your client matters are being taken care of? And by you, I also mean the people who work for you. And just make sure you really know what's going on. Don't assume you don't have to know what your staff is doing. You need to be looking for all sorts of things. Do you see unusual expenses being submitted? On the last conversation just the other day, they talked about a lawyer who went on a business trip and forgot his running shoes and decided he really wanted to go running while he was on this trip. So he bought a new pair of running shoes and then he submitted that receipt as ground transportation for reimbursement from the firm. And so you need to just keep an eye on that kind of stuff. Do you see unusual expenses being submitted? Do you know which vendors you use? Are the invoices legitimate? How long has it been since you made sure your staff, including your new staff, knew you had policies? We saw some recent Colorado disciplinary cases where and it ended up being at the same firm, 2 separate lawyers basically deferred all of their responsibilities when it came to client engagement to a paralegal. Unfortunately for them, this paralegal was nefarious and a bad actor and wasn't doing things properly, which shouldn't have been delegated. The paralegal should never be the one preparing and presenting the engagement agreement to the client. The paralegal shouldn't be the one handling the money, right? So they didn't know what this paralegal was doing. It turns out the paralegal wasn't doing things properly. So ultimately that responsibility lies with them. The paralegal separately was investigated and prosecuted for the unauthorized practice of law, but those lawyers also received serious discipline when it came to their licenses because they weren't supervising. So make sure you're not asking your staff to take an outsized role in the representation. Make sure that there are certain things you don't delegate and that you keep in charge of so that you truly know what's happening. Ultimately, as the lawyer, you're the licensed professional and the responsibility is yours. While you can delegate, and we all delegate, there are certain things you shouldn't delegate, and you just need to make sure you're following the proper standard of care. Watch out for the unworthy client. Unworthy clients worry me all the time. Not because we have them, but they lurk out there. Look for areas of concern. Ensure that yellow flag questions are answered. If something niggles at you, follow up on it. I am going to tell you almost every single lawyer I talked to when I investigated allegations of lawyer misconduct with the Office of Attorney Regulation Counsel, at some point in the conversation, almost every single lawyer said, I knew this would be the one. I knew this was going to be the client that grieved me. And my second question was, why did you continue representing that client? Or why did you take that client in the first place, right? Your gut instinct is a real thing and you need to listen to it. If your gut is telling you that something is just wrong here, you need to listen to that. So ensure those questions are answered. Encourage your staff to be invested and to share concerns they might have or knowledge they might have. You'd be surprised. It is a small world, and every once in a while, a secretary might come to you and say, hey, I know that guy through my kid's soccer. He's the uncle of my kid's friend, and he's like had 6 bankruptcies, and I'm worried he might not pay his bill. So think about things like that and encourage your staff to be invested. Stay on top of your billing and accounts receivable. Clients that get outsized AR balances, that's often an indicator that there's an issue. Research new clients if you haven't previously represented them, not necessarily giant companies, but individual clients, especially if it's going to require you to front costs or front money in any way. Don't let your inclination toward entrepreneurship cloud your judgment. If you have a doubt, listen to that doubt and don't be afraid to withdraw. It never ceases to amaze me the degree to which lawyers do not like to withdraw from representation. And I get that. There's something about I'm in this with the client, but don't be afraid to withdraw if you need to. Mistakes are a growing area of concern. In recent years, mistakes have become one of the leading causes of malpractice claims against lawyers and law firms. Mainly, that's just the press of time. We're doing a lot. We're doing it in a short amount of time. There's cost concerns, there's client demands, there's all the other stuff, and it's hard to slow down. And clients get conditioned to expect rapid responses, and they expect to get that at a minimal cost. There's also, if there's a crunch of time and you need to bring on staff, did you have time to train them? Are you supervising them like we talked about? So there's all these things that go in. And there's this, which I stuck in my drawer before we started today, your mobile device. Beware of responding from your mobile device. I have a rule that I use my phone to read emails. I try never to respond because I caught myself one day typing an answer that was written out of frustration, that was way too harsh. And I thankfully caught it before I hit send. But my goal in life is never to send something I will regret. And doing that from a mobile device is risky. There are many cases where big malpractice claims have come out of lawyers responding quickly from their mobile device while they were distracted, providing bad advice, and ending up costing their firm sometimes millions of dollars. So please be cautious about your mobile device. Make sure you're not recycling work. Make sure you're calendaring deadlines. Make sure you understand the applicable law and that you're keeping on track. Take adequate time, reduce your distractions, use time buffers to reset so you can move from one project to the next. Plan ahead, aim to beat, not just meet deadlines. There should be no last day filings. You should always have a no last day filing policy. If nothing else, file at 5 p.m., not midnight. Don't wait to ask for extensions. Use checklists. Hospitals have found that they can reduce the rate of infection by 90% if they just have checklists, and one of those checklists says, step 1, wash your hands. This seems obvious, right? But hospitals found that when they put checklists in place, they reduced risk of infection by huge percentages simply by reinforcing to people what they needed to do. The intangibles, right? These are no less important, but they're harder to define. Times are hard. We're living in a time of extreme stress. I just sort of listed, this was maybe my therapy slide where I just kind of listed all the horrible things that I think are weighing on all of us. I had this conversation with this kid at the coffee shop down the street the other day because I'm that desperate for human interaction that I like make friends basically on the street, just if it's a human being and they'll talk to me. And we agreed that we're all sort of living with low-level depression right now. Thankfully, some of us are doing better than others, and we all need to be thankful we have our jobs, but life is heavy right now and times are tough. And that's going to exacerbate existing mental health conditions with those of us who already live with them or trigger new ones where they might not have existed before. But how do we do that when we're not together, right? Lawyers generally have high rates of mental health conditions, substance abuse disorders, and other addictive tendencies. If you have been around long enough and you practiced and you went to CCLEs at the Bar Association, you will remember Gary Abrams. And Gary Abrams' favorite things to say was that lawyers have now a higher rate of suicide than dentists. And he always thought that was funny, and it got a laugh line, and I heard it like 1,050,000 times. But sadly, it's true, right? Our mental health issues or conditions are compounded by times of stress. And if this isn't a time of stress, I don't know what is. When we're in the office together, we notice these things. But when we're working remotely and we aren't together, things that already were problematic might be more problematic, right? Now more than ever, this is real, and we need to be looking out for each other. Not only does that impact our ability to effectively and ethically practice law, but it has severe impact on us as a human being. And one of the things that I say a lot and people make fun of me is, you know, yes, I'm sitting in the executive director chair, but I'm your colleague. I'm your coworker at CORE, right? And I am concerned about you. And regardless of what the problem is, I want to be a part of the solution with you. So let's care about each other. Normally we know what's going on, right? Drinking alone when you're alone all the time. I pulled some statistics, you've all seen this, but suffice it to say, because I'm already over time, the rate of alcohol use during COVID is skyrocketing. I was shocked when, there was kind of that whole hullabaloo when we went into lockdown, but liquor stores were able to stay open and there were lines down the street. And I was really, really shocked to hear the director at Denver Health say, look, beds are full right now with COVID patients. We can't be helping people work through alcohol withdrawal. And if that means that we leave liquor stores open so they can get their fix, then that's what we're going to do. And that was really, really sad. And it's really sad that drinking has exponentially increased during this time. And there's a risk there. And we need to be looking out for each other. And we need to be figuring out how we can still have contact and touch points and look out for each other when we're not together. Some various things you can look for: changes in appearance, mood, performance, personality changes, increasing anger, agitation, or moodiness, although I will admit I think we're all a little more moody, withdrawing or isolating, engaging in risky behavior or neglecting things that didn't used to be neglected, being overcome with hopelessness, overwhelmed by the circumstances. Pick up on what people are saying to you. Don't just listen to the words, but listen to what might be behind them. These are harder to spot during COVID times, but someone's life could literally be at stake. Don't pretend to be a doctor. I remember we had someone when I was at OARC, and a friend called and said, look, this person's threatening self-harm, and this person is a lawyer, and I really think there could be an issue here. And, people were like, we got to get him in here. And of course it landed on my desk. And if you know me, I'm not great at touchy-feely, but it was like, we got to get him in here. And I was like, what possibly am I going to do? Like, I'm not a therapist, and I could do more harm than good. And so know your strengths. And if you're not a mental health professional, don't pretend to be one. And the answer there was to get this person the help that they needed from a professional who was trained to do it, not me, who would just be playing a doctor on TV. Encourage people to seek help. Let them know what resources are out there. Almost every law firm these days has employee assistance resources. Let them know that those resources are there, that they're confidential. Make it clear that the goal of mental health programs is to get them help, not punish them for reaching out. And sometimes even when help is not sought, it's still needed. So have a plan for your intervention. If the person is not saying they need something, but it's pretty clear that they do, don't wing it. Have a plan going in for what you're going to offer, how you're going to be supportive, and how you're going to do it. And express concern. Let them know what's available, but don't judge. And I keep saying this to everyone. Now is the time to extend grace, first to ourselves. Don't beat yourself up for things that happen. Just figure out how to deal with it. And by deal with it, I mean, don't stuff it inside, but figure out, who do I need to talk to? I've made a mistake on a case. How do I remedy that? What partner do I need to go to? How do we fix it? But don't beat yourself up over it, right? Figure out how to fix it. So extend grace to ourselves and extending grace to others. And with that, if you've seen me speak before, I always end with a picture of my dogs. I have 3 of these at home. This is how I cope with stress. Thankfully, shelters are pretty much empty right now, or I might have 5 and then my husband will move out and I'd have a whole different set of problems. So this is Edgar. Edgar and I are all ears, so let's hear questions.
Thank you so much, Amy. I really like Edgar, and I think Edgar would have a plan like you.
Yeah.
You should, and would be able to read the rules and have checks and balances and set expectations, and when in doubt, not do do it and use checklists.
That's right.
We have a couple of questions
Okay.
in the queue. The first question from Dave Hesterkamp: is there an updated version for the confidentiality disclaimer that goes in the signature portion of our emails that you would recommend using based on the changing technology rules?
It's really, the confidentiality disclaimers are really a fascinating topic to me, because technology professionals will tell you that you should have it so that you can show that you take this seriously. But I think technology professionals would also tell you that it's, in all honesty, sort of useless, because you're saying these things, but there's no burden on the person receiving, unless it's a lawyer who has obligations under the rules of professional conduct to actually comply. But that said, we all still have one. And I think at base, it just really has to say, if you're not the intended recipient of this message, then please don't read it and let me know you got it and just destroy it. At its core, that's what you need to say. Beyond that, I see people cite different rules and different laws and all this other stuff. And really, at the end of the day, the technology disclaimer is really relying on someone to do the right thing. So I don't think there's a perfect format for it, as long as you just cover the basics.
Okay, thank you for that. We have a plug for Mental Health First Aid Colorado. This is a great training for general public on how to spot signs of mental health distress and how to provide immediate assistance. We'll put that link in the chat or in a moment, or if somebody could help me put that in the link. It's www.mhfaco.org. So to continue the education. Question here, also from Harry. Do you know if the CBA Ethics Committee hotline is still operational? I called them last week to discuss a complicated conflict question and never heard back from anybody.
Well, that's unfortunate. The CBA Ethics Hotline is still operational. And actually, I was a member of the CBA for many years, and I was the chair of the CBA Ethics Committee in 2017 and 18. And the hotline is one of the most valuable tools that the Ethics Committee offers, because it's the way to get help to lawyers in real time. So it's unfortunate you haven't heard back. I'm sorry you haven't. I would call back and just let the CBA know that you called and hadn't heard back. If you didn't talk to a live person and left a message, perhaps leave another one, but definitely let them know you already called and you hadn't heard back, and hope that they escalate it. Typically, they're really good about that, but just let them know.
Thank you. Another question, Bill Fisher asks, what are some of the best practices for handling issues of collecting fees from clients that are slow to pay? This has been a problem that's been aggravated with the pandemic.
It has. And a lot of clients, I don't know, depending on your practice area, what we found with a lot of corporate clients, and I think many law firms did, is corporate clients just started asking for extending from 60 days paid to 90 days, or 120 days, in one case 180 days. So clients are also pushing that envelope, but hopefully they're communicating with you. I think best practices really is to just start to watch those AR balances as they get older than what is reasonable, right? 30 days, 60 days, 90 days, anything over 90 days really should be something that you're following up with the client about. And it's really going to depend on your practice area and your relationships with your clients. If you represent corporate clients and you have a contact in that corporation, it's, often you're uploading your bills through these pay systems, and you know that this client generally doesn't pay for at least 45 days. So you're not even going to start worrying until that point. But just know your clients, know when to start thinking that it seems unusual, and then just start reaching out. And if you represent individual clients, it's going to depend on your circumstances as to whether you can afford it, but some money is probably better than no money. So offering a payment plan, or setting yourself up to take credit cards via Square or other systems that you hadn't previously utilized, just being innovative in how you're thinking about it and trying to find methods that work with your clients, especially if they're individual clients, just so you can get some money in the door.
Very good advice. Thank you, Amy. Seeing no more questions, I want to thank you so much for an informative ethics presentation. And I wanted to let everybody know who participated today. By early next week, you will receive a link to the presentation and a survey to share your thoughts with us. And Colorado attorneys will receive the CLE affidavit, excuse me. I want to add a word of thanks to the terrific team for making this presentation possible. Thanks to Yesenia Delgado and Teresa Coberly. Before we close, I wanted to do one plug for Race in the Law series that we have. The Denver City Attorneys are doing on Tuesday, October 27th. Tackling racial bias in the midst of a global pandemic, the city's response to COVID-19, legal aspects of public health orders, compliance and enforcement. You'll receive information about that, and Yesenia just posted how you can register. If you're interested in registering, there's a link right there. Again, thank you all for joining us, and I wish you a wonderful Wednesday. Be well.